My boyfriend and I were playing last night, and I put him in a suitcase and we were playing. I'm the blue-eyed white dragon, that's what they call me.
For the purposes of trial, you will be hands-free and you will not be shackled with legs.
Okay, so I would be unbound.
Correct.
I know this is a lame question, but what does sustain mean?
Sarah Boone could have the help she wanted when she appears today in court with her new attorney. But the suitcase murder trial could be delayed yet again if Boone and her counsel get their way. And from Dancing with the Stars to a domestic abuse charge, the arrest of a dance pro married to a retired WWE wrestler is leaving us with more questions than answers. Also this hour, a woman accused of killing her husband says that her 7-year-old was one of 2 people who really murdered him. We're talking with her defense attorney live. Plus, Donna Adelson's last court appearance gave us an idea of what her upcoming trial could look like. It is all coming up next for you right here on Opening Statements. Good Tuesday morning to you and welcome to Opening Statements. I'm your host, Julie Grant. We hope you had a wonderful long weekend, and let me tell you, we spent some time planning a great show for you this morning. So let's get right to it. Let's get to that coffee in court, as we call it. Grab your cup of coffee right now. It's time for my opening statement. A drunk driver on the road is like an unguided missile in the air. They strike without warning. They kill indiscriminately, and they need to be taken seriously. I hear it all the time. A DUI is no big deal. Wrong. It's always a big deal because you never know when somebody's going to get killed. People across the country are brokenhearted after hearing the news of 2 beloved hockey players killed allegedly by a drunk driver. NHL star Johnny Gaudreau and his younger brother Matthew, who plays in the minor leagues. They were out for a bike ride and, according to police, killed by a drunk driver on the eve of their sister's wedding. Police say the man who hit and killed them admitted to having 5 or 6 beers before getting behind the wheel of his car. And what's more, that man reportedly is a major in the Army National Guard and works at a rehab center. DUIs are serious crimes. You know why? Because they can cost people not only their own lives, but also the lives of other innocent people. And in this case, we are mourning the lives of Johnny and Matthew Gaudreau. That is my opening statement. Let me know if you like it. Right now, it's time for your daily docket.
I didn't think anybody would even care. Didn't think it would matter to anyone. I didn't think they would believe me. I didn't think there would be enough anything to have anyone even want to listen.
We've got jury deliberations resuming this morning in the broken trust abuse trial. One of the jurors was replaced with an alternate on Friday, so the deliberations had to restart. Now, those will continue at 9 a.m. Eastern. We'll keep you posted. Also happening at that same time in Florida, we've got jury selection beginning for the fatal family birthday trial. Alexandro Del Toro Jr. is accused of murdering his mother while fighting with his father after a birthday party. And we've got Sarah Boone back in court this morning. Brand new motions expected to be heard, and she's supposed to have a brand new attorney. We're going to be talking about that. 9 a.m. is the time. We're going to go there live when it begins. Now, that is, of course, our top story for you this morning. So many of you interested in the suitcase murder trial, right? And we've seen delay after delay after delay. And, well, guess what? This morning we're seeing that Sarah Boone may have a little help in the courtroom from an attorney from Pensacola, Florida, who is stepping up to represent her. Now, if you remember, she's gone through 8 lawyers previously and was essentially made to represent herself.
For the reasons that the court identified in its 16-page order previously entered, your request for standby counsel is denied.
So Sarah Boone then created an advertisement. Remember this? She advertised for an attorney to help her, and it appears it worked. Because on Friday, attorney James Owens filed his notice of appearance and then immediately filed a motion asking for a continuance. In the motion, he noted that he was drawn to the case after, get this, seeing her advertisement from watching court TV. How about that? Now, in an interview with us, Owens says, quote, "She hired me. She retained me. It's a little different because it wasn't someone who was handed to her. She picked me. I plan on seeing it through, and I'm determined to help her see it through." End quote. All right, we'll see what happens this morning. Let's talk about this. I've got two great guests standing by. The Director of Prosecution Projects at Florida International University. She's a former homicide prosecutor. Melba Pearson is with us. And want to welcome back in forensic psychologist, expert witness, Dr. Michael Brannon. Great to see you both. Oh boy. Okay, so the likelihood, let's just assume that everything works smoothly. He shows up at court this morning. The judge notes that he is now counsel of record. Will he be given a continuance? Melba, what do you think?
Yeah, good morning, Julia and Doctor. I think that he's going to get that continuance. It would be an appealable issue, I think, if he doesn't, because he's brand new, just stepping into the case. He has to have the opportunity to read the file, prepare. If he was just retained on Friday or basically in the last couple of days, there's no way he can get up to speed to effectively try this case. So I think a short continuance will be given to him. Now, I don't think it'll be 3 months or something like that, but I could see a scenario of a couple of weeks to a month in terms of a reset date in order for this trial to finally move forward.
Sure, appreciate it, Melba. I have a little bit of the motion for continuance we extracted just to see a little bit of what he says. And get this, he talks about meeting with Sarah Boone 4 times at the Orange County Jail already. And he says during the meetings, they discussed exculpatory evidence on her phone, which they hope will potentially corroborate her battered spouse syndrome defense. Dr. Michael Brannon, this is where I want to bring you in. We all saw you testify in Marsha Thompson's case, and you were really the star of that trial, the breakout star of that trial. Your expertise really shined. Looking at this case, and I know you haven't personally evaluated Sarah Boone, but based on what you know and the facts we see them, do you think she could be successful on a battered spouse syndrome defense?
Well, good morning, Julie, and Melba, too. Good morning. So it's a very difficult defense, even when everything is all put together nicely for the defense to occur. And there has to be a number of different elements that fit in order for the battered spouse defense to be successful. And in this particular case, you know, there's a reason why people go through a lot of different attorneys. Some of them may just be stall tactics. Some may be trying to establish a certain defense. But attorneys may be, and again, I didn't talk with her, I don't know that much about the case, but attorneys may have already told her, listen, you don't meet the elements of this, or this is not going to be successful, trying to give her the benefit of their legal knowledge and background, and she may not have been willing to accept that. She may have heard from other inmates or family members, or she may have seen court TV and thinks it may be a good idea, but the facts of that, the elements may not apply directly to her case.
Appreciate that, Dr. Brannon. We know in one of the motions that her new attorney filed, he said that he's looking for additional discovery. And of course, that caught our attention because we're thinking, what else is there? We've been talking about this case for years. Melba, as you know, you've given us analysis for years on this one. What else could possibly be there? It seems like Sarah Boone is hung up on discovery, quote unquote. We've seen her, you know, there before the judge saying, you know, I'm not being given everything. I'm not being given everything. And, you know, looking as a spectator, you know, someone who's on the outside. I'm not part of the case. I'm not the prosecutor. I'm not her defense attorney. You know, I'm just scratching my head because we know there were 2 people at that house that night, the 2 of them, when this happened, and she created the most incriminating evidence by filming him and not letting him out of the suitcase. Melba, do you think this motion could have teeth? Do you think this is a formality? I'm curious your legal opinion on why this attorney would say he thinks there's still something outstanding that hasn't been turned over by the state.
So, of course, as in any prosecution, you have the duty to turn over any evidence that you're going to be relying on in trial, or just generally, and my always rule of thumb was always, when in doubt, send it out, right? So that way there's never an issue later on down the line. You didn't turn this over. This could have been exculpatory. You mentioned this in trial. I didn't have access to it before, et cetera, et cetera. So sometimes in homicide cases, when you have a lot of different witnesses, you have many different people that authored reports, you may not, there could be a situation maybe where one or two reports didn't get turned over. It happens. It's, often accidental, not anything untoward, but it happens. So it's possible that the defense attorney, in the abundance of caution, is just renewing his request for any and all discovery that might be pending, just prompting the prosecutor to go through the file again and just ensure there wasn't anything turned over. Now, of course, it could be a stall tactic on the side of the defendant, because again, yes, to your point, Julia, she knows what discovery she created, but also it's a tactic to know, is there anything else out there that can be used against me? And how do I deal with that? How do I handle that in advance of the trial?
Excellent insight from you as always, Melba. Thank you. Dr. Brandon, let me go back to you, please, on the issue of battered spouse syndrome. Sarah Boone, we know, is a very strong-willed, shall we say, woman who seems to know what she wants. She had difficulty getting along with the 8 prior attorneys. Maybe 9 will be lucky number 9, who knows. But tell me, if she is intent on going forward with this defense, or at least exploring it, what does that look like from your perspective in consulting? Would you kind of take us behind the scenes? How would that go?
Sure. So you'd want to know right away whether there's any control tactics that were being done by the victim in this case. Was there a pattern of abuse? Was it ongoing? And was the individual, the victim in this case, so controlling that she wasn't allowed to contact, be in touch with other individuals, be in touch with family members to try to get help? And did she make other attempts to try to get away from the abuse? And I'd also note that the method of death here that was utilized by Ms. Boone on the victim, it would be unusual for a battered spouse case. Usually the actions are impulsive, they're quick, a quick gunshot or a quick stab wound. But this type of killing is really unusual and almost unheard of for battered spouse cases. So they'd have to overcome that as well, because it appears that there's some thought, some intent, but also some lingering time for her to think about what she's done. And oftentimes those are not synonymous with battered spouse defenses.
I appreciate it, Dr. Brandon. So in terms of what we may see today, Melba, as we go into the courtroom, what are you expecting from the judge? Are you expecting the judge to willingly accept this attorney's involvement in the case now?
I mean, he doesn't really have a choice. It's one of those situations where this is who the defendant has selected to represent her. And so the judge has to give him the same equal treatment he would give to any of the other attorneys, whether it be the first one or the 8th one that showed up in court. So he has to listen to the defense counsel's argument as to why he needs a continuance, how long he thinks he would need, what he's seeking, or if he knows what specific piece of evidence is missing or what piece of discovery hasn't been turned over, laying that out. So the judge is going to have to listen to all the arguments and make a decision as to if he's going to get a reset or a continuance, and if so, for how long.
Appreciate it, Melba. Dr. Brandon, tell us, what are you looking for as this progresses? What are you listening for, watching for with Sarah Boone's trial?
So does the evidence show a pattern of abuse, and does the evidence show that she's tried other methods to try to escape from that abuse? And remember, these are difficult defenses, and the reason why they're difficult is you're asking jurors to not believe what they see, but to really believe what they can't see, which is what a person's thinking and feeling. And the attorneys in this case, with their evidence, have to be able to show what she was thinking and what she told other people, and not just what she did, but what she didn't do. All those things are very, very important in establishing a battered spouse syndrome case. In this particular case, if she hasn't shown those elements, it'll be difficult to get that forward with a jury.
Appreciate it. Excellent insight from you both. Dr. Michael Brannon, thank you kindly. I know we need to let you go and get on with your day. Always a pleasure to have you on opening statements. Thank you. And Melba Pearson's going to be staying with us as we continue the show. We hope you do the same. As we come back from this break, we're going to talk about how a Napa Valley arrest has put the focus on one high-profile celebrity couple. What do the charges in this case tell us? That is what's trending in true crime. Plus, Donna Adelson back in a Florida courtroom last week as her trial is quickly approaching. We'll talk about what ruling is tipping the scales.
Join Court TV's Vinnie Politan.
In every story, in every trial, every case, there's at least two sides to it.
To dive into the latest.
Oh my God.
And breaking true crime stories.
This was a very targeted, very personal attack.
Inside.
I've never seen that in Discovery. I've been incarcerated 3 years.
And outside of the courtroom.
She's a psychopath.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates. Tonight, 9/8 Central. Only on Court TV.
My name is Chigmintsev, and I've been on Dancing with the Stars for 8 seasons.
Very happy that I got Artem. I body slammed him and he survived. That means he can handle me.
Oh, very talented couple they are. Many of us know Nikki Bella Garcia and Artem Chigmintsev. We know them from the WWE and from Dancing with the Stars. Now, one of them has been arrested on domestic violence charges. Chigmintsev was booked in the Napa County Jail last week on a felony charge of corporal injury to a spouse. The dance pro was then released from jail later that day after posting $25,000 bail. Now, it's not yet confirmed if the charges are connected to Garcia, who is presumably, though, the spouse in question. Now, the arrest came just days after the couple celebrated their second wedding anniversary. Chigmintsev posted these photos you see here to commemorate the occasion. The couple married in 2022 after welcoming their first child in 2020. And now these two beloved performers have the spotlight on their marriage for this reason. And the details are still very limited this morning. So the first question we're asking, what does the charge tell us legally? Let's bring in our power panel. Still with me, former homicide and domestic violence prosecutor Melba Pearson, domestic violence expert and former law enforcement officer Claudia King, and retired criminal defense attorney, the man who famously represented Jodi Arias, Kirk Nurmi. Let's talk a little bit about what we can glean just from the charge, And I'd like to start with you, please, Claudia, being a law enforcement officer, also being a domestic violence expert. We see corporal injury to a spouse or intimate partner. What do you make of that legally, please?
So in California, that charge is kind of a step up from just a battery charge. It indicates that there was some type of injury that caused a, quote, complication to the victim. So it's something that's going to be more serious than what you would normally see. Additionally, I believe he was charged with a felony corporal injury. So that means it's even more so on the serious side because there is a misdemeanor charge that you can have in that case as well. So whatever happened, it does seem to be that there was credible witnesses or witness and good evidence to show a serious injury to the victim.
Claudia, you're spot on. I have a statement that the Napa County Sheriff's Department issued to E! News. And here's what the public information officer said. When someone is charged with felony domestic violence, usually this means there's a visible injury or credible eyewitness. Napa County Sheriff's Department public information officer said in a statement to E! News on the day of the arrest. And an additional statement reads, our deputies felt comfortable arresting him on felony domestic violence charges. Melba Pearson, let me go to you next, please. What else do you think we can possibly glean from the charge, from the grading of it, and from the language in that California statute?
So it sounds to me, based on what we're seeing in the statement and from the charge itself, that no weapon was used, or at least no weapon is alleged to have used. So we're not looking at gunshot wounds, we're not looking at stab wounds or anything along those lines, but that still doesn't mean that something serious couldn't have happened. So it could have been a situation where, you know, you threw a lamp or a pot or a pan or a dish or something along those lines, and it may have hit the victim, causing her some injury, whether it be bruising or something along those lines. It doesn't sound like a severe injury like a broken bone, but to me, it's sitting more like a black eye or some kind of bruising. But I also want to know, just because of the fact that she is involved in WWE does not make her immune from being a survivor of domestic violence. Because again, a lot of what we may be seeing in the videos is for show, but the reality and the real dynamic behind closed doors may be very, very different and may be very toxic.
Oh, thank you for that, Melba. Thank you so much for that. You're exactly right. That's a really important point. You know, what they both do for a living, they both are incredibly talented. They both have big fan bases. They both have made livings performing. That should have nothing to do with this investigation. You're absolutely right. And so thank you for that. I want to continue with you, please, Kirk Nurmi. Last but certainly not least, to our first question this morning, what can we glean from the charges? Tell us what you thought, you know, when you heard of the charge, what, if anything, jumps out to you legally, please?
Well, we know that in California and a lot of other states, there are certain, assessments that officers are making and that mandate arrest, right? Because so many instances of domestic violence in the past were ignored. So now we have mandatory arrest statutes. And what we really have here, to put on the defense attorney hat right now, is we have allegations. We have an officer or two believing that there's enough to charge this man. We don't know what that evidence is. We don't know the details, and we don't know if it's really supported. So right now we have the assessment of a few officers. So whether that assessment is accurate or not, and we can go back to, this has to Harbinger Depp v. Heard, right? We don't know the validity of these allegations yet. They're easy to make. They're easy for officers to obsess and make an arrest, but there's going to be so much more to it that needs to look into before we can really point the finger of domestic abuser at anyone.
Excellent points, Kirk. Excellent. And I'm so glad you brought that up, the investigation. Let's talk about it now. So we know that according to a 911 dispatch audio call that was released, we know that Garcia was connected to an alleged altercation that happened at the couple's Napa Valley home, and that led up to her husband's arrest. Chigvintsev made the initial 911 call requesting medical assistance, and then we know that he called back to cancel it, and he said that his wife threw shoes at him. Now, we know days before the arrest, the former WWE star, she's also a Hall of Famer in the WWE, she also posted a highlight reel of the couple's Paris wedding to her Instagram. And over the weekend, she broke her silence on the allegations. She did it through her representative, simply stating, quote, "This is a private matter, and Nikki asks for privacy for her and for her family at this time." So to Kirk Nurmi's point, what comes next in this investigation? Let's bring back in our power panel. And Kirk, let me start with you this time. So what are the next steps? Kind of walk us through what you expect to be seeing happen in this case, please.
Well, I certainly expect that everybody's going to get a lawyer. Everybody involved here, we have a high-profile case. Everybody's going to get a lawyer, and they're going to be consulting with their lawyers. From the prosecution standpoint, I don't know how much investigation is going to be left. They're going to talk to the victims. Hopefully they're going to have lawyers. So how far that'll go, I don't know, but they're going to have to look at those injuries and be able to prove that there was an assault that took place, because visible injuries don't necessarily correlate to causation or who caused them. So they're going to have make sure that they have tangible physical proof that this man caused these injuries, or else they're not going to have a case. So they're going to have to take a look at these injuries, look at what they can prove before if they can move forward with the charges or consider offering a plea.
Kirk, thank you for that. Claudia King, let me go to you next, please. Walk us through some of the steps. Who do you expect to be interviewed first? And do you think we'll see, perhaps the couple's child, who's 4 years old, be interviewed?
I think, like Kirk said, everybody's going to have an attorney. So, some people may speak and some may not. I would expect, though, for the prosecutor to follow up with the victim and potentially the child. But at 4 years old, I really don't expect that to be a credible witness, who can articulate what really happened in that moment. And other than that, they're just going to look at, was there any medical intervention provided, whether in that moment or later? So they would obtain those medical records if they exist, and any other treatment that happens after the incident. But other than talking to the people who were there and assessing any injuries and any treatment, there's not really too much else they can do unless there are cameras in the home. They could potentially get that footage and be able to see exactly what occurred in the moment.
That's a really good point. They probably will be looking to see if there are cameras or anything else, if anything was recorded. Excellent insight from you all. Of course, we'll continue following this story. We're noting that it's very, very early in this case, in the process. If you or anyone you know is a victim of domestic violence, 1-800-799-SAFE is the National Domestic Violence Hotline. Claudia, we have to say goodbye to you. Thank you so much for coming on the program and weighing in this morning. We'll see you very soon. And when we come back, we're going to turn the attention and spotlight the My Daughter Did It murder trial happening next week. Laurie Shaver, accused of murdering her husband, but she claims that her 7-year-old daughter is the one who killed him. Her defense attorney joins us live next. Welcome back. This morning, we're spotlighting a trial that we're going to be covering for you next week. It is the My Daughter Did It murder trial of Laurie Shaver. Shaver is accused of shooting her husband, Michael, to death in November of 2015. Michael Shaver was working as a monorail technician at Disney, and his remains were found buried beneath a fire pit in the couple's backyard in February of 2018. Now, Shaver claims that her now teenage daughter confessed to killing Michael when she was just 7 years old. Now, on Friday, Shaver appeared in court. The state won a very important motion to exclude testimony from a witness who talked with the defendant's daughter about what she said happened when her father was killed.
The second portion of the state's motion focuses on statements made by the defendant's daughter, Isabel Shaver, to Mr. Narvaez. As we know, the defense is going to potentially be that Ms. Shaver, Isabel Shaver, was the one that actually shot the victim. Ms. Shaver made statements to Mr. Narvaez years later indicating such. Those are clear out-of-court statements made by a witness, Ms. Isabel Shaver, to Mr. Narvaez, used to prove the truth of the matter asserted, so they are clearly hearsay.
All right, so here with us this morning, we want to welcome in Laurie Shaver's attorney, Jeffrey Wiggs. Jeffrey, good morning. Thank you for coming on the program.
Good morning. Thank you for having me.
Certainly. So soon after Laurie's daughter said that she killed her father. This was soon after Laurie was arrested. Apparently, the child made this admission. And so this is kind of hard, I think, for all of us to wrap our heads around. A 7-year-old girl admits to killing her father then. What's changed now? Fast forward now here, we're getting ready for trial. What, if anything, is different?
Well, really what happened is the child had stepped forward at the beginning of this incident and relayed to me what had happened. I kept it really very brief and had an attorney, independent attorney assigned on her behalf, and that's Kelly Johnson. Kelly represents the minor child, but the minor child has always persisted. She wants the truth to come out. She wants the jury to know what happened. So she feels regretful what happened, but the whole matter was a matter of defense for her mother. She stood there and watched her mother being beaten, saw her mother crying for help, and the father threatening to kill her. That's how this matter surfaced. Ms. Johnson and myself went to the state attorney's office. We wanted to relay to them that this child had stepped forward and what they might want to do. There was another individual in the house at that time that actually discharged the gun after the minor child and disposed of the body. We relayed that to the state. They were not interested in getting down to the truth and really digging into this as we were. But here we go. Now we're set for trial.
So a couple questions. I want to take these in turn. So the other individual who you're saying was there, who is this boy? Is this an ex-boyfriend?
Yeah, Miss Shaver at that time was dating a man by the name of Jeremy Townsend. Mr. Townsend walked in, incident to the child shooting the father, who was not supposed to be in the residence, and came in the residence trying to persuade Laurie to go back with them, and she wouldn't go back with him. And then this altercation erupted. He was shot and was sitting in a chair, and Mr. Townsend came in and finished him off, told Miss Shaver to get the kids out of there and he would take care of this. He took the body somewhere unbeknownst to Miss Shaver, and later it ended up in the backyard, unbeknownst to Miss Shaver. They had an area that they were preparing to make a duck pond out of. It later got abandoned, and that became the patio.
So when did she start dating Jeremy Townsend?
Well, it was some time before then. The exact dates, I don't know. Either Miss Shaver will testify to that. We've subpoenaed Mr. Townsend, having relayed to the state what had happened. I don't know if Mr. Townsend, will show up. We have been unable to get service on him. He has an attorney. We asked if they would accept service. They indicated they have, but I haven't seen a return of service come back.
Gotcha.
So I presume Mr. Townsend has some deal negotiated with the state, whether he shows or not.
Mm-hmm. And Jeffrey, you mentioned maybe Laurie will testify to that. Is your client, Laurie Shaver, going to testify?
That's always a decision I leave to the client. I advise them one way or another as to my feelings on the matter, let them make the ultimate decision at the trial. After they've heard the evidence, let them make the decision.
Sure. So backing up again, I want to go back to the child who was 7 years old at the time. How in the world did that child know how to operate a firearm?
This child, no age has been placed on this child. The child was deposed. The state inquired as to her age. The child really couldn't articulate as to her precise age at that stage. The state doesn't have a firm date of death regarding Mr. Shaver. They have a speculative death based on their own conjecture. The medical examiner was deposed. It was his testimony. The body could have been in the ground for a matter of months to several years. So that's incumbent upon the state to establish the date of death, but they're going to have some problems with that issue amongst others.
Appreciate that. So there was also evidence about alleged abuse that's been blocked from coming into the case. How might that affect your defense case, Jeffrey?
Yeah. Well, this was a marriage. This man repeatedly battered Laurie. And we're not fabricating this. There's court records that show applications for injunctions. There's a prior conviction on Mr. Shaver for battery. And multiple DCF reports. There will be some inkling of information that comes out. Now, I'm concerned, as anybody should be, that other incident reports and other data don't flood the trial to where they become the center of the action. But there's photos of injuries and other events that occurred, and the minor child will be testifying and give testimony why she acted in this manner. And I expect that child and those photographs and some of that testimony and the prior events will come in that fashion.
This is quite a case. As you well know, Jeffrey Wiggs, thank you so much for coming on the program. We certainly would welcome you back after everything gets underway, and take good care, and we'll speak again soon, I hope.
Okay. Appreciate your time. Thank you.
When we come back here on Opening Statements, we're going to talk about what Mama Donna Adelson doesn't want the jury to know as she gets ready for her murder trial.
Go ahead. Hit me. Bam.
Two celebrities reveal their turbulent relationship to the world.
He was just Hollywood's mega hunk.
The man who beat me up for 5 years.
The general public sees this, and all they see is wife beater. Two completely different versions of what was happening. That means one thing: somebody's lying.
Victim to Verdict with Ted Rollins. New season premieres Sunday night, 8/7 Central.
Only on Court TV.
Mama Donna Adelson is back in court on Friday as we're looking ahead to her upcoming trial and what could tip the scales. In court last week, the judge heard a flurry of defense motions, including one about Adelson's arrest at the Miami airport. Her defense team wanted to prevent prosecutors from arguing that her attempted flight to Vietnam, one-way ticket by the way, showed that she had consciousness of guilt in the murder of her former son-in-law, Dan Markell, but the judge didn't buy those defense arguments.
The motion is going to be denied. I do believe this is a matter that goes to weight versus admissibility. The finder of fact, the jury, is going to determine whether Ms. Adelson was in fact merely researching a vacation or if she was in fact seeking to avoid prosecution, or this is consciousness of guilt.
Adelson's trial just a few weeks away, so will hearing about her one-way ticket to Vietnam tip the scales of justice? Let's bring back in attorneys Melba Pearson and Kirk Nurmi. Melba, you're in Florida where this trial is happening. You've been a prosecutor there for years. Talk to us a little bit about the flight as consciousness of guilt instruction and how that's going to work out here.
Yeah, so of course, this is not going to leave the best viewpoint to the jury in terms of her concern as well as her consciousness of guilt, right? So the fact that she tried to flee definitely could lead jurors to the conclusion that she is guilty of the crime. So this in and of itself is not going to be enough, but you have to layer it on with the other aspects of evidence that the prosecution would be laying forth in their case in chief. So I think that the jury is going to be instructed by the judge to say, listen, you're going to see this one particular aspect. This can lead you down the path of coming to a guilty verdict, but you shouldn't be relying on this alone. This is one thing that can show the mindset that the defendant had at the time that they looked up the flight or bought these tickets, et cetera. But you probably should not be relying on that as the sole indicator as to whether or not the defendant is guilty or not guilty.
Sure, Melba, thank you. Kirk, tell me, looking at this from the defense side, should they be upset about this, or do you think this was an expected loss on that motion?
I think this is an expected loss. This is always relevant evidence when we talk about consciousness of guilt, and her actions, her post-killing actions are going to be relevant. As you know, in particular, I think the biggest thing that's going to tip these scales, Julie, is those phone calls with her son Charlie that apparently helped motivate the arrest. So there's so much against Miss Adelson now. This is really about giving her effective assistance to counsel at this point. The dominoes of the Adelson family are falling, and this is just going to be one more issue for them to grapple with, and they don't have a winnable case. I don't see it.
Mm-hmm. And Kirk, and let me ask you a follow-up too, please. With respect to Charlie and the calls, so we can see that there's been a transport order put in for him. He's in a prison in South Dakota, and he's going to be transported for trial to be a witness. Curious what kind of a witness you think he's going to be in terms of who he's going to be most friendly to, mom or the state of Florida. What do you think, Kirk?
Boy, it's pretty hard to say, Julie, because, you know, one thing you've probably heard me say before is jail changes people, right? And so here we have a successful dentist. He's been an upper-class person all his life. And is he going to have some resentment towards mom, who apparently was the one who got the ball rolling? She's the matriarch of this family. Is he going to hold some resentment against her for his situation now and the rest of his life? or is he going to try to protect his mother? That's really going to be a tough question. It's going to see how the conditions of confinement really have changed his life, because obviously he's willing to take part in this for his mom, but is he angry about it?
Yeah, great points. Melba, tell me, when we look at this from the prosecution side, and we think back how this has just been a Herculean effort for these prosecutors to get this case done, and it's just been one by one, like they're just chipping away. Could you kind of give us some insight into what's that like? I mean, could they just try this case with their eyes closed, probably at this point?
Yeah, well, one of these things I think you probably are aware of is that you eat, sleep, and breathe this case, right? And we see something similar in terms of we were watching cases on court TV and we're following along. Take that times 50. Right? Because you're literally just almost obsessed in a way. You have to be just laser focused on this case and making sure that all the discovery has been turned over to each of the defense counsel, keeping track of who said what when, making sure that you have charts so that you're able to not only keep the story straight in your own mind, but make sure you're effectively transmitting that story to the jury. So there's a lot of moving pieces, and you're so immersed in it that a lot of it becomes second nature, but you also don't want to take something for granted because, oh, that was something I introduced in the last case, but you forgot to do all the appropriate steps to introduce it in this case. So it's definitely really intense. The familiarity does make the case easier in a lot of ways, but there's still a lot of challenges, no matter how many times you're back in court in front of the same judge with similar witnesses.
Sure. Melba, thank you for that. Kirk, let me go to you, please, on something that we saw playing out at that Friday hearing. We saw Donna asked about her right to waive the conflict that exists because of her attorney having represented her son, Charlie. And she is adamant. She wants, his name is Daniel Rashbaum. We saw him in action in Charlie's trial. She's adamant she wants him. She's saying she knows the risks. So many of us watching this were just cringing and like, how is this going to work out? Especially when he's probably going to come in and give testimony, and so his lawyer is going to be crossing him. Kirk, I'm curious your thoughts about what kind of a mess this might present.
Well, a huge one, really, because especially when you talk about that cross-examination, a reason that this doesn't happen is because an attorney has information regarding their client, their former client, in this case, his new client's son, and he's going to have information from which he can cross-examine Charlie with that he wouldn't otherwise have. Could this open up the avenues to new crimes for Charlie? What basis for that information has Charlie decided to waive the conflict? So there's a lot there. It could bring up a whole mess, but also at the same time, she's asking for particular representation and being denied that. So that's going to be something that's looked at as well. But I think the conflict is pretty solid, and the judge is well taken to, have other counsel move forward.
Great insight, Kirk. Thank you for that. The judge in this case, it is very apparent he knows how to run a trial. The Honorable Stephen Everett is his name, and he denied the defense motion to move the trial to a smaller courtroom. They were saying, oh, you could control it better, Judge, if it was in a smaller courtroom. Let's take a listen to what he said.
Anyone who is acting inappropriately will be removed from the trial. If this even goes to the issue of contempt and trying to influence the jury in an improper way, believe me, I have no problem having them break out the handcuffs. You can ask around.
Love it. That was probably the one as we got a soundbite of the day in that hearing. Everyone is going, oh, the judge is not going to be pushed around by any of these lawyers or witnesses who try any funny business. Melba, let's talk about that. The impact, the judge has on the trial overall.
Yeah, so I love how the judge made it very clear. If you don't know, now you know. Like, govern yourself accordingly, right? So it is very important for that judge to really set the tone. Like, listen, this is a high-profile media trial. There's going to be a lot of raised temperatures within the courtroom. I'm not going to tolerate any foolishness. We're going to keep this about the facts. I'm going to make my rulings swiftly, and we're going to keep this train on the track so that this victim can get justice, this family can get closure, and this case can finally be resolved, whether it be a guilty verdict, not guilty verdict, whatever the case may be. So the judge plays a huge role. I think we saw that in the OJ trial, how unfortunately Judge Ito really, did not have the best viewpoints in terms of the way he was able to control his courtroom. So I think judges from there are trying to learn from that mistake.
Oh, exactly. Great discussion with you both. I can't wait to have you both back on for analysis once her trial kicks off. September 17th is the date. We're marking our calendars. Melba Pearson, Kirk Nurmi, thank you both for your insight and expertise. We'll see you soon.